that we were extremely disappointed with the reasonings provided in the majority judgment, because it sounded like the judgment of the previous federal court with a little bit addition of some flesh. Nothing much that was added that would have impressed us that we were wrong. Okay? For instance, cases that we have obviously shown to be completely non-applicable was cited again, just as the previous federal court cited, like the Halaman Perdana case, which has got no application whatsoever. And conveniently, they did not handle the issue of the circular, about the circular that was applicable to the lower court, which was also given CCs to the High Court and the Supreme Court, regarding the discharge of counsel. They did not deal with that. Okay? And in the end, of course, we are further disappointed with the conclusion and the result of the majority judgment. But we are very encouraged, and I must say this, you can see that in spite of losing this case, I am still in the smiling mood because of what was said in the minority judgment, the dissenting judgment, which took double the time of quick reading than the majority judgment. In fact, it was 84 minutes of reading, and the previous, the majority judgment was only 48 minutes of reading. Of course, length or quantity doesn't matter, but it is the quality that is important. Now, I thought highlight to you, this is what was held in the minority judgment that sort of excites me, because it is something which I expected a judge of the caliber of Rahman Sebli, the Chief Judge of Sabah Sarawak, to come up with, going by the historical background that we know about all his judgments, which are quite illuminating and upright. Okay? Now, he said this. He said, out of the 4 grounds, he was only interested to make a decision on just 1 ground, namely the adjournment, which is the 2nd ground out of the 4. Yeah. So he says on the adjournment, and he started by saying that Rule 137 is critical because it is a rule that not only is to propagate justice, but he calculatedly used the term, it is to stop the perpetuation of injustice, suggesting that what is going on with Datuk Seri Najib was injustice, and he has to stop that perpetuation of injustice. So he said Rule 137 is applicable in such situation. That's important. And he says Rule 137, even if you go by the law, is applicable when fair trial has not been given to a person. And in this case, he went down the route and held that fair trial was not given. The process was completely not provided to Datuk Seri Najib. Now, this is how he says it. He says that justice is not about finding out whether someone is guilty or innocent, or not guilty. Guilty, not guilty, or innocent. Justice is not only about that, but justice incorporates a bigger concept, namely whether when you come to the decision whether a person is guilty or not, did you apply the process that will enable him to say, yes, I have been given the fairest of trial, but unfortunately I lose, or fortunately I win. So the process is very important. Now, why you need to stress this is because it applies to you and me. Next time maybe it's not you, It could be your children, it could be your father, it could be anybody. If he is charged in court, you must be confident that the court will give you a process of fair trial. Because only the process of fair trial, you can be assured that the judges is giving you the chance to prove your innocence, or for the prosecution to prove your guilt. So if you don't get this, then you can say virtually that fair trial was not given to you. Now I want to jump a little bit. This judge in the minority held that there was no fair trial. The adjournment should have been given, he said, because why should the adjournment be given? He said because the new lawyers took over the case only 3 weeks beforehand. Okay? But he said it is not relevant about Shafi and Co. that was already there 4 months before, because Shafi and Co. was no longer the lawyers, because they were replaced by Ziz and Hisham. So you have to consider the new lawyers. So the new lawyers had only 3 weeks to read over more than 30,000 documents and judgment, which are 800 pages in the High Court and another 300 plus pages in the Court of Appeal. So you see, it is humanly impossible. So in the context of that, he said adjournment should have been given, and he says it is routinely done in especially serious cases. And you remember we cited the case of one person who got 70 odd adjournment. You know, nobody complains about it. Yeah, because if he needed the 70 adjournment, he should get a 70 adjournment. But this is the first time we ever asked for adjournment. Never before in the history of Datuk Seri Najib. So I want to impress upon you that because he thought fair trial was not given to my client, this judge did not order for a retrial in the federal court. He said because the infringement is so drastic, so big, he ordered an acquittal and discharge. That means if Rahman Sabli was the majority, Datuk Najib today is acquitted and discharged and there is no more trial on the SRC. It is that serious. And he is the most senior judge there who decided today. So bear in mind, we pleaded either you acquit and discharge or you order a retrial before a newly constituted federal court judge on the appeal. I mean, the appeal be reheard, because Tunku Maimun and her 4 judges did not hear us. You remember we said they heard the prosecution ex parte, one-sided. They never heard from us at all. And they held that when Hisham stood up and said he cannot submit, it is not because he refused to submit. It is because he's being responsible. He has not been prepared because he just got it 3 weeks earlier. And therefore, he cannot do injustice to the client by submitting when he's not prepared. You know, like if you are being defended by a lawyer, you will be very, very upset if the lawyer is not prepared and yet he carried on with your defense, because that's the best way to hang you. You know, sometimes the lawyers themselves can hang the client. Doesn't have to be the prosecution. So the lawyer must be fully prepared in order to defend you. And this is your basic right. All right? Okay, now, then he went on about the adjournment. He said, why shouldn't the adjournment be given? Because the adjournment was requested a lot earlier. The prosecution did not object. On 2 occasions on record, he read it. The prosecution leave it to the court, no objection. Not only that, the prosecution sent the Solicitor General. This is the 3rd occasion. The Solicitor General stood up and said, we leave it to the court on the request for adjournment. Which means they were quite confident, the prosecution themselves was quite confident that the request for adjournment was genuine because they need to prepare. There was no such thing as, was it applied to delay? Because if it was applied to delay, the prosecution will make noise. The prosecution at that time never had any idea that this was a ploy or anything like that. They all thought this is a genuine request for adjournment. And it remains a genuine request. But only here, they began saying that this is a ploy for adjournment, which the judge just now gave them a rap on the knuckle and says this was an afterthought. All right, so the minority judgment say once the application for adjournment is genuine, you have to consider it in a reasonable fashion. You cannot simply say this is a discretion of the court, because the discretion of the court must be exercised judiciously. That means just because it is discretion, you cannot do as you like. You have to consider judiciously, because if you don't grant adjournment, it may cause injustice to this man. So that's why you have to be judicious about every decision, including for adjournment. Now, then we went on to a sub-issue, which is this. He says, he examined this concept of, can a counsel discharge himself? You remember Hisham discharged himself at one stage. On the 18th, he discharged himself. But the court said, no, we are not allowing you to discharge yourself. This dissenting judgment said, there is no such thing as not allowing, because the circular, as well as the two cases we cited, when you engage, assuming you engage me, it's a private contract. The court cannot enforce it. The court cannot say, you must continue engaging me, because that's enforcing a specific performance. If she wants to sack me, that's it. The court have got no say, because it's a private contract. So the court say, this was a private matter between the client and the solicitor. If the counsel says he is discharged, he's discharging himself, the court has got nothing to say about it. In a criminal case. Now, a dangerous precedent was set today by the majority. Now, the Bar Council representative was there, and I'm sure she's very concerned. Now, they say, in every criminal case, for a criminal lawyer to discharge himself, he must seek the permission of the court. Now, you tell me, in a last-minute appointment of lawyers by, say, people who are without lawyers, say, legal aid people, you know, people who are without money, you know, like indigent client. If suddenly they say they met you in court and they say, can you help me, can you defend me? No lawyers will accept, because the court will force them. You accept, you jalan the case, although I'm not prepared. That is the dangerous precedent which the court majority judgment has set. Whereas previously, if I'm not ready, I ask for an adjournment. The court always gives. I've never come across one single case where the court never give it, unless it is habitual that you've been asking 5, 6, there's one case 17 times asking for adjournment, so the court can stop you. But in a genuine case, in order to achieve justice, the court always gives you the adjournment. And the discharge of counsel is the counsel's privilege together with his client. So the court decided today, in the minority judgment, that it is wrong not to discharge, not to allow the discharge of the counsel. In fact, the court went in a conclusion by saying, the reason why the Chief Justice or the previous court insisted that Hisham stayed in court was to give it the appearance, is a pretended impression that my client was with a counsel. That's why it doesn't allow the discharge. That's very dangerous, because if you have a counsel that is not prepared, it is as good as not having a counsel. You remember the Chief Justice decided in one case, I did, it's called Yahya Hussein. Yahya Hussein was previously defended in Tawau by a lawyer who never knew anything about criminal law, especially dangerous drugs. And what transpired was, he collected the money up front and he pretended to defend. And then we realized later on why he wanted to do the case, because the lawyer was dying of cancer. So he needed the money, took the money, but he didn't defend. And he was almost going to be sentenced to death. Then the embassy called us, and then we read the record. See, this is crazy. The IO was not cross-examined, main witnesses were not called, the wife who was present in court was not called, and so on. So we applied for additional evidence, and Tunku Maimun held that, among other things, she said, an incompetent counsel is as good as no counsel. In fact, she said an incompetent counsel is worse than not having a counsel, because an incompetent counsel can compromise your case, because you are as though represented and yet not represented effectively. So if we apply that case, you force Hisham to stay there in order to give it an appearance of being defended, and therefore the minority judgment said that is illusory. I mean, to give it an illusion that justice was in fact being provided in the process towards justice. So those are very strong words used by the minority judgment. And finally, he held, therefore, that on the basis of no adjournment, on the basis of discharge not allowed, this is a serious transgression into Article 5, the right to a fair hearing and the right to counsel. And therefore, he said the transgression is so major that he said he orders an acquittal and discharge, not a retrial. Okay? That's the short of what transpired today. If you want to know further, you can ask me. But if you have any other question, you can also ask me.
What is your next step,
Okay. This minority judgment has given me a lot of encouragement. We have just heard from United Nations that our application in United Nations has started being processed, and there is movement to ask the Attorney General to respond. So we would send further documents, including the minority judgment, to them so that they will examine, because now there is a judicial finding. Okay? We will also send a majority judgment so that the United Nations will see which judgment is a lot more sound. They will see it and then they'll come back to us. That's number one. Number two, on the power of pardon by the Yang di-Pertuan Agong, it's very critical that the Yang di-Pertuan Agong has got the opportunity to read the minority judgment, which condemns the way the case was being handled. And I use the word strongly because the minority judgment literally condemns how the previous federal court conducted themselves in not allowing the adjournment and in not allowing the council to discharge themselves. Only on this issue. He didn't even have to go on the other three issues. He already made finding quite clearly that this is a very bad precedent for an unfair trial that was executed on my client. So these two, definite. But there is a possibility of another action in the court. This one I don't want to disclose yet because we want to organize our thinking in the light of the judgment which we are going to collect in a short while. And we will inform you in due course what we are doing. So it is not the end of the matter. Yes.
Denda 210 juta, dah bayar ke belum?
Apa dia?
Denda 210 juta.
Oh, no.
Dah bayar ke belum?
No. How do you pay 200 million? When the 200 million has been, all the money that was put in the account was spent on charity and political purposes, not for his pocket. It's all spent. So, quite clearly, that money you cannot recover because you paid it towards welfare, towards political funding, and so on.
So you mentioned there's another possibility in the court. Is another review of another option that
one we cannot disclose yet, whether it's a review or another procedure.
but it will be a court procedure.
It can be a court procedure because the other two are not court procedure.
But review is a court procedure.
Yes, yes. Anything else?
Datuk,
Yes.
you can comment, earlier the dissenting judgment mentioned that Datuk Seri Najib paid the price for the mistakes made by the lawyers. Would you like to comment on that?
Thank you. I forgot about that. In fact, the word he used, you managed to decipher from that, because I thought that was a very strong point he made. The learned judge said that he paid a heavy price for the mistake of lawyers, which ought not to happen. Because if you exercise justice and process properly, a mistake of the lawyer is a mistake of the lawyer. If you want to punish a lawyer, there is contempt, there is disciplinary proceeding. The court never took contempt against the lawyers. So why should Datuk Seri Najib suffer? Especially when you have already determined, the prosecution also determined that the application for adjournment was genuine. It is not a ploy to delay, right? Okay, that's a good point. Yeah. So it's a very serious point. They made a finding that there is admission that the lawyers were at fault. The lawyers themselves admit. Yeah? So the lawyer's fault should not be attributable to the client.
Sir, earlier on during the prosecution's press conference, Sidang mentioned he hopes that the SRC case, in fact, says will end, no more litigation. How would you respond?
No, I think SRC case very unlikely will end that fast. Very unlikely. Yeah, because I think my client is, even if my client gets let's assume for a moment he gets a pardon, I think he will still want to fight in court because he's very determined that he did nothing wrong. Okay, he was misled by people in the SRC. He never moved the money. He never had the control of the money because he was a prime minister. Why should he have anything to do with the account of SRC? So, well, we think this case it has been decided on grounds which are a bit difficult to comprehend. And that is the reason why we thought we should take it all the way. And we are surprised that the current federal court, the federal court just finished, didn't even allow. Why not allow him to re-argue the matter? Because he was not prepared the last time. What is the problem if you allow him to re-argue the matter? Is there a fear that he may get acquitted? Yes? No. As a result of the minority judgment, which I thought was a lot stronger than the majority judgment, there is avenue that is open. Because there are cases that say review is not only once. If there are grounds, as long as there are grounds for a fresh review, you can always review. And the other thing is, of course, we got the United Nations as well as the pardon matter that is ongoing.
Are you going to send a second review? Are you going to...
He just asked me. I said, I cannot tell you at this moment. Okay? Yes.
If there is another review application, how much time do you have to wait in the period?
No, there is no time period. There is no time period. But the first review we file in within 2 weeks. The one that you just heard. Within 2 weeks we file it after the first federal court decided. So we will try to do it expeditiously. Any other question? Thank you. Thank you.
Tadi dulu.